All right. And Ms. Jackson, are you ready to proceed on your motion today?
I am.
All right. Ms. Stevens, are you prepared to proceed?
Yes, I am, Your Honor.
All right. Ms. Jackson, I'll allow you to argue your motion at this time.
The motion that I set forth to modify parenting time has come over an extended period of time. It was not a sudden decision. It was years since we had moved. Things have changed. Situations have changed. Some things had gotten better at a certain point. Some things got worse, and then now we've been on a continual decline of co-parenting, communication, and the like. And unfortunately, not only does that have a negative effect on both of us as adults, it also inherently has a negative effect on the child as well. Even if she is not privy to the conversations, she's been aware of the fact that, her parents aren't friends, to say it that way. There are more concerning issues that I have brought forth in the motion, and there are just things that when the motion was put in place, she was a toddler, or when the prior order was put in place, she was a toddler, and she's now in school with an actual schedule. So there are things that just need to be reworded.
What is her age now? Is she about 7?
She's 8.
8. Okay.
So some things are just administrative in nature to update based on the fact that she's no longer 3 years old and is 8. Other things, just wording needs to be more specific so that ambiguity no longer causes communication breakdowns. And there are definitely some larger issues that I take within the way that the parenting plan is currently written, and with issues that have continued with the emotional state of the child in regards to the situation.
Ms. Jackson, let me, I've had an opportunity to review the file, but this is the first time that I've dealt with a hearing regarding these parties. You live in Colorado, is that correct?
That's correct.
And where in Colorado?
Aurora.
All right. And Mr. Rankin resides in Park City?
Wichita.
Wichita. All right, go ahead.
I'm not sure if you want me to go straight down the line of my motion or address the issues that were brought up in the motion to dismiss first.
It's your motion. I'll allow you to present it how you see fit.
Okay. The first issues, obviously, that are the biggest issues probably to have in forefront are any violations of the parenting plan, which are listed under number 3, specific violations referencing back to the original parenting plan. Those were all of the things that Ms. Stevens had brought up in the motion to dismiss. No specific, I did not bring up specific changes within any of those. The first change that I asked for is later, but the issues that are brought up definitely do go towards changes that I did request. First one being the whereabouts when on vacations and extended trips with the minor child. Any change to the parenting plan that I requested, obviously I know and have no issue with it going both ways to both parents. I can't say that it has happened both ways because I have not taken the child out of the country. So the only example of that is a one-time occurrence. And I also have not taken the child out of state, short of taking her to the state in which Mr. Rankin lives. we had a lot of issues during a cruise that was taken out of country. I wanted additional information. Ted felt that it was not necessary to give me that information and stated as much as can be seen in Exhibit 1 of my response to the motion to dismiss. He felt, based on the wording of the current parenting plan, the only thing he needed to tell me was that he was taking her out of the country. And though that may technically have been the case due to the wording of the parenting plan, I feel like proper and effective co-parenting should not have been an issue to give more information when it was requested, given the fact that he was taking her out of the country. I had to obtain legal counsel in order to get that information that I asked for. I was able to get that once my, at the time, representation contacted Mr. Rankin about it. But I think that definitely needs to be updated within the parenting plan to include additional information just short of one of us saying, hey, I'm taking her out of the country. And it was brought up in the motion to dismiss that was intrusive. And I personally don't believe requesting additional information of, for the cruise, for instance, dock dates, travel dates to the dock, where the cruise is going, without forcing the other parent to have to find that information on their own, which I did end up having to do. Thankfully, I had the name of the cruise line and I was able to deduce which cruise it was, but I don't feel that effective co-parenting should force that situation.
Ms. Jackson, can you reference where in the existing order you're requesting this modification?
All right, guys, buckle up, because this case opens in a very calm but already loaded courtroom atmosphere where tension is quietly building under routine formalities. The judge simply asks if both parties are ready to proceed, and both confirm without hesitation. It feels procedural on the surface, but underneath it signals the start of a deeper legal conflict that has clearly been building for a long time. This short opening moment sets the tone for everything that follows, where emotion will slowly give way to structured legal confrontation.
Within the parenting plan or within the motion?
Within the original parenting plan?
The original parenting plan?
Because you're seeking a modification of language in the original order, if I'm hearing your argument correct. Is that accurate?
It's not in the place that makes sense. So
And just so we're all on the same page, is the agreed order and parenting plan filed on September 17th, 2020, what you're seeking to modify?
yes. I believe the only time that it is actually mentioned, and this is also why it needs to be added and changed, is in the original parenting plan under C. It's actually, I interpret this to actually be regarding the residency, but this is what has been discussed before when the conversation was brought up, where it says, 2, removing the child from the state or the child's state of residence for a period of time exceeding 90 days. That has been Mr. Rankin's argument before, that he did not need to tell me because he wasn't removing her for longer than 90 days. We don't have a lined out specific verbiage for out of country travel or even out of state travel, which I think definitely needs to be added for both sides, so that we have a knowledge of where our child is, even when with the other parent.
All right, I understand that argument.
The next issue brought up specifically within the violations of the parenting plan, which leads to the change that was requested. Each parent is allowed reasonable telephone, text message, email, and video access to the minor child at reasonable hours without interference from the other party. There have been issues. He's brought issues up, so I will say that there have been issues on both sides regarding the time in which a phone call happened, or most often a FaceTime video call that happens, be it when she is in the car, things like that aren't always the most convenient. And the language that is within the parenting plan is very rigid, and almost it's definitely a point of contention, almost a point of malicious compliance sometimes.
And again, when referencing the original order, can you point out where in that order you're referring to?
Yes. That one is number 11, which I believe is page 8 of the parenting plan. Again, at the time that this parenting plan was put into place, the child was 3 years old, and a toddler of that age is hard to keep on the phone anyway, even when it is a video call. So putting in that to have minimum telephone or video contact with the minor child on set days for at least X amount of time was justifiable at the time. That way we could ensure that the opposing parent at the time that did not have the child could have communication with her. However, she's older now. There's times where she doesn't even want to talk on the phone. Then it has happened on both sides. As I bring up in my response to the motion to dismiss, during this current parenting time, there was a time in which they had actually just gotten back from a weekend vacation of sorts. And I had sent the text to have her call. They said they weren't home. They'd be home later. I said, okay, have her call me when she gets home. She got home, found that some of the neighbor friends were outside playing. She apparently had said that she wanted to call the following day instead of that night. And that was fine. I feel like at 8 years old, she has the ability to know whether she does or doesn't want to be on the phone or at a specific time, rather than rigidly trying to force her to sit on a phone call for 15 minutes. I think at this point, it would be better served to further limit communication between two people who have had co-parenting and communication issues, to allow the child to have the autonomy to speak to both parents at any point that she wishes. My husband and I previously gotten her her own cell phone that she uses when she is here. She has not taken it to Mr. Rankin's house. He at first did not agree to her thinking that she needed one. In some ways she doesn't. She's not on her own or alone at any time. It was more so that she had the freedom of conversation between other family members and her father without having to utilize one of our cell phones in order to do so. She's perfectly capable of utilizing it. In the motion to dismiss, it was mentioned that Mr. Rankin was open to the idea of her having her cell phone there, but that he wanted to have the control to say when it was or wasn't needed. I do take issue with one of us defining what is needed in regards to communication for her. If she is here and she feels the need to text her dad or call her dad, and it's not a Tuesday, Thursday, or Sunday, there's no reason that she can't do so.
What specifically what kind of language are you requesting? Is it just that the child should be able to communicate with either parent when she feels it appropriate?
More or less. Number 7 within the proposed parenting plan that I submitted would allow for her to utilize her cell phone that I do note is provided and paid for by myself. I have had no intention of requesting any financial reimbursement for the cell phone from Mr. Rankin, to be clear on that. But to use it for communications with the opposing parent that the minor child is not currently with, allowing her to utilize and retain possession of the cell phone for personal use, as well as not solely for the communication of the other parent. Thus being due to Mr. Rankin stated that if her cell phone were brought to his house, he would take it and give it back to her only to call me, which eliminates the natural flow of communication that she could potentially have with me while she is with him and with him while she is with me. I did note that in addition, due to the nature and symptoms of her medical diagnosis of ADHD, she is only 8 years old, and therefore there are certain things that are harder for her, like remembering to charge her phone. It's an issue that we have here as well, and I think it's important that we have a common ground across both homes in order to help and assist her to learn.
All right, guys. Now we step straight into the core of the dispute as Miss Jackson begins laying out the foundation of her motion. She explains this is not a sudden filing but the result of years of deteriorating co-parenting communication and unresolved tension. What becomes important here is how she frames the situation as a gradual breakdown rather than a single incident. She emphasizes that the child is indirectly affected by the ongoing conflict between the parents. The key turning point is her statement that the child was a toddler when the original order was made but is now 8 years old, in school, and living a completely different routine, making the old structure feel outdated and increasingly impractical.
I don't think that this means that she is unable to utilize a phone. I just think she has certain issues with certain things due to a medical diagnosis. Cell phone's not the only thing she forgets to do, just like any other 8-year-old, and sometimes it's a little more because she does have that medical diagnosis of ADHD. It also, utilization of her own personal cell phone allows her the privacy that she has indicated to me that she does not have or does not feel that she has while she is there.
Are you anticipating that this provision only apply to contact with either one of her parents and not with whoever she wants to be calling?
No, use of her cell phone. She has the phone numbers for at least 2 of her siblings, her grandparents, all saved in her phone. She does she contacts my mother on occasion. She does talk to one of Ted's other children as well, who is not always at his home. But the utilization of the cell phone being exactly how we all use a cell phone. Not to say that rules don't apply in households. We have them as well. She goes to bed, it gets plugged in our room. She doesn't have access to her phone all through the night, things like that. But and I would assume that there are cell phone rules for the other children in Ted's house as well. I don't know what they are, but even though they are a little bit older, I assume they probably still have rules that apply to them. But she has little games that she plays sometimes, no different than I feel probably any of us do on a cell phone. She is restricted on how long she is allowed to be on her phone. I feel that it would probably be the same way there, regardless of whom she was talking to or anything, but it allows her continued communication with other family members. And right now, I think she's only got one friend in her phone, but we do have I feel important to note, we do have parental controls on the cell phone. She does not have full access to everything. But I feel it would be important to not have specific days or times in which she is allowed to contact whichever parent she is not with. it just puts a hindrance on a lot of things, not to mention a hindrance on whichever parent is waiting for that phone call.
Right. I understand the argument.
The next issue, I don't know that there's a whole lot that really needs to change about wording, more just the parenting plan needs to be followed. Within paragraph 12 of our current parenting plan, it states, neither party shall make disparaging remarks about the other party's significant other, or the other party's family members in the presence of the minor child. And it goes on, I believe it is, let me make sure. Exhibit 3 that I submitted with my motion to dismiss is one of the most obvious forms of disrespect and disparagement that has come from Ted, certainly not the only one. There have also been comments from his wife as well, and from what the minor child has stated, his spouse's mother has also, she's indicated that she has also spoken negatively within earshot, not specifically to the child, but within earshot. There are a lot of communication issues that happen between Ted and I, which is why I believe it's in everyone's best interest for us to use a third-party communication application to help avoid issues like what he has me saved in his phone as, which was brought to my attention by the child. She thankfully did not fully understand what the words were, but she knew that it was not my name. And then
what is it?
And the second image on exhibit 3 at the very top, you will see what I would prefer not to say that.
Did the party, do you all not utilize a parenting app?
Not yet. Ms. Stevens did indicate that he would be in agreement to doing so, however.
All right, guys. At this stage, the judge takes control of the direction of the hearing, shifting everything toward legal structure and clarity. Instead of emotional explanation, the focus turns to jurisdiction and factual grounding. The court confirms where each party resides, establishing the legal framework for the case, including Colorado as a central reference point. Ms. Jackson is then guided on how to properly structure her argument within the boundaries of the motion. This moment is critical because it transitions the case from narrative conflict into formal legal procedure, where every statement now needs to connect directly to the written parenting order.
Okay.
Within my motion, I did request that I don't know how it is normally done, but I request that the cost of that, which I believe can be done yearly, be split 50-50 between the parties.
Okay, go ahead.
The C under my motion to modify leads into the biggest request within the motion that I believe Mr. Rankin had an issue with, which is understandable. The minor child's mental and emotional well-being, as well as her own thoughts, feelings, and desires, I believe should be considered. I understand that at 8 years old, we're not talking about a 16-year-old who has, a certain level of perceived emotional maturity. However, 8 years old, you do still have feelings, emotions, and thoughts and opinions. I don't believe she should be controlling everything about her life, but I do think that her feelings should matter. She has indicated both to me and to a third party that she does have very strong negative feelings about a lot of things. My position has never been, and I've never stated that she hates or dislikes everything about her father or going to her father's house, anything like that. I do believe that negative and positive feelings can coexist within the same person about the same situation. And I believe that's what she is currently dealing with, a conflict of emotions where she feels certain things are incredibly negative, but there are obviously positive things. It is her father. She does love him. And that's just how it is. That can happen all the way up to adulthood, in my opinion. Due to that, there have been multiple times where she has requested not to go to her father's, which I have told her that unfortunately, I don't. It's not something that I can just decide unilaterally. She understands that I don't just have, complete control over that. She has indicated not wanting to go for as long. She has indicated not wanting to, go back after a period of time. Unfortunately, these are not things that she currently has control over. Again, nor do I believe that she should just be able to say, no, I don't want to go, because at any point a child could be, unjustly, ticked off at a parent for something, and that should not indicate whether or not she has visitation or parenting time, however it's worded, with that parent. But I do believe that I believe a reduction in time during the summer would benefit her. 4 weeks is usually pretty difficult for her. From what I understand from talking to her this time, the current parenting time has been positive, at least for the most part. She does not feel like she has the ability to speak freely about all aspects of things. So I usually do get an unload as soon as I pick her up. But I feel like a termination of parenting rights or a complete removal of parenting time is not justified and not necessary. I also feel like should the relationship between the two of them be consistent in how they feel. Mr. Rankin has indicated he believes it's all positive, and our child has indicated that she does not believe it to be all positive. And should that change and things become, a better, more positive for her, there really wouldn't be any reason for that to, in my opinion, to go back up. And that would again be, if the child indicated, hey, yeah, I've been at dad's less, can I stay an extra week or something the next time I go, things like that. I feel like she's old enough to be able to indicate that things are more positive, that she feels more positive and happier when she is there.
So is your request for a reduction in Mr. Rankin's summer parenting time tied into this paragraph C on page 4?
In part, yes.
Okay.
It's also partially tied into paragraph D, where there have been choices that have been made that I do not feel have the child's physical safety at heart. Within the motion to dismiss, it was argued that Mr. Rankin follows all car seat laws, always has, and has always listened to what I say. Unfortunately, that is egregiously wrong. It has been a point of contention since our daughter was an infant, as to how to properly install car seats, which car seats she should be in, can she move to a booster, et cetera, et cetera.
Is she in a car seat at age 8?
She is in at least in my vehicle, she is in a high-backed booster because she is very small and relatively short. So she does not pass the height and weight requirements to not be in a high-back booster, at least not for the car seat that I have. And following the American Academy of Pediatrics recommendation and the highway safety recommendations, which is what I follow. I happen to have a car seat that it was one that was extended. You could use it for like 10 years, provided it was never in an accident. So it's very easy for me to alter it without having to change what seat she is in. I don't know what type of booster or car safety seat she is in within Ted or his wife's cars. I believe she's in something. I just don't know exactly what it is, because she indicated to me most recently when they had driven to Texas for to port for the cruise, she was told that she could get out of her seat and lay across the regular seat in order to sleep better, which obviously is not car safety for her size. I actually don't think it's indicated for anyone to do that. And that is just one particular occasion. There was another occasion where she said she was told not to tell me that she was not in her seat because it will just make your mom mad.
All right, guys. Now the dispute sharpens as the conversation moves into a specific and highly contested incident involving out-of-country travel. Miss Jackson raises concerns about a cruise taken with the child, arguing that proper information was not fully disclosed under the parenting plan. The tension here comes from the disagreement over what required notice actually means in practice. While one side believes the obligation was technically met, Miss Jackson argues that effective co-parenting demands transparency beyond the bare minimum. She explains she even had to seek legal counsel to obtain details, which escalates the seriousness of the disagreement and highlights how communication between the parties has broken down into legal interpretation rather than cooperation.
Another instance of safety issues was she indicated to me that they went out to buy shoes. They frequent Silver Dollar City, where there's theme parks with amusement rides, and she, like I said, is kind of short. She is tall enough for the 48-inch, not tall enough for the 52-inch, I believe, 51, 52-inch. She indicated to me that they intentionally bought her tennis shoes that had a thicker sole, so that it was said to her she would look taller, to make her taller, and she said that she was taught how to stand with her heels slightly up to make herself appear taller so that she would be tall enough for the ride. It was also indicated on a phone call. I happened to be in the room putting laundry away and overheard her make a comment to her father about it not being that I had mentioned to her that it was not safe for her to be on rides that, maybe she really wasn't tall enough for. And the comment that was made, whether in jest or not, was, well, we got you on the ride. That's all that matters. Like I said, may have been said in jest. However, I don't find that particular situation to be something that is laughable in any manner because children have died. And I do think a disregard for physical safety, no matter how small, can be problematic and can be indicative of a much larger issue when gone on and not nipped in the bud, so to speak, so as not to continue physical safety issues. It also ties into paragraph E, where the minor child has indicated that she fears Ted. This is not at all times. This is not, just being in his presence that is fearful to her. It is certain actions, certain words. She has indicated, I would argue, normal parenting things, he raises his voice. Okay, we all do. He believes in spanking. I do not. It's a difference in parenting opinion, and I can't do anything. I can't do anything about his, his opinion on that. But he does have a significant history of physical violence when it comes to domestic issues. And she has indicated that she has seen what she describes as her father being scary or having scary behavior. She has also indicated to me that at one point she hid in the bathroom with her older sister while her stepsister was being yelled at, and at which time Ted broke her cell phone in his own hands. I don't know if that part was seen or if it was just a knowledge that she had based on what she could hear, but she did indicate that the two girls did hide in the bathroom during this altercation because they were scared. She has also indicated that she has fear of his spouse at times. Again, not 100% of the time. It's not her presence. It is certain behaviors. She has said that his wife has grabbed her arm before hard. That it feels like she's harder on our child than on other children in the home. She has also indicated that there is a significant disparity in the way that she is treated by her stepmother when her father is not around versus when he is. And she's also indicated that she has had fears before of her stepsister due to continued blame for things that she indicates she did not do. And one particular instance where she said that a bag was placed over her head and her arms were held down so she could not take it off. And it was done when she asked why that was done, it was indicated to her, well, because it was funny. I wasn't there. I can't say exactly what happened. This was the perception of, at the time, a 6-year-old having something happen to her. I do think that it is worth noting that though they were found to be unfounded, unsubstantiated, what have you, there was in fact a DCF report on both Ted and his wife. I don't have any information on what the one towards Ted was, short of what was in the very vague notice of findings that I received. I believe that one was emotional as opposed to physical. I know the one against his wife was physical. I did hear about the incident prior to finding out that anyone had reported it to DCF. I was accused of being the one to report it. I was not. It was not the first time that she had told me about a situation that was similar. Unfortunately, it probably did not have the same. I didn't get in an uproar and immediately contact Ted about it. But the same version of the events that she told me is what I was told from Colorado DCF that was told to them through the report. Again, I don't have any idea who made the report, so I can't say how clear, concise, or effective in communication that was. It was found to be, unfounded, unsubstantiated, and I can't argue with that. That's how it was found, but worth noting that it was there to begin with. And she has indicated to me and to my husband and a third party that she had been in fear of behaviors prior to this incident. I do request in the new my proposed parenting plan. Figure out exactly where that is. Number 29, I do ask that physical discipline or punishment not be allowed in any way from any party in the minor child's life. Or in addition, the direct threat of physical discipline or punishment not be allowed in any way. I understand there's a fine line, in my opinion, between a difference in parenting types and something causing a fear within a child that is unnecessary. Spanking on the surface, I don't agree with. I was spanked as a child. I understand that it's a pretty common practice. However, it has caused emotional and fear issues within the child for being spanked. And I feel like there's a lot better ways to handle conflict with a child who is getting older as opposed to physical discipline.
All right, guys, this part shifts into a technical but important legal breakdown of the parenting order itself. The judge presses Ms. Jackson to identify exactly where in the original agreement her requested changes apply, forcing the argument to become precise rather than general. The 2020 parenting plan is brought into focus, especially language related to relocation and travel restrictions. What becomes clear is that the wording leaves room for interpretation, particularly around out-of-country and extended travel. Ms. Jackson argues this ambiguity is at the center of the conflict, as both parties interpret the same clause differently, leading to repeated disputes over compliance.
Indicated in part by the exhibit showing what he has me saved in his phone as. I have absolutely no idea what his wife has me saved in his phone as, but I also know that at the time that I was told by our child, it was also not my name. She knows what my name is. She knows how to spell it. She said that's not what it is in Nicole's phone either. But I don't know I have no record of what that one is or was, if it has been changed since. Paragraph G, there's been multiple accounts that the child has come home and told me that comments were made to her regarding being asked if she wants to live with them, and suggesting, going so far as to suggest, well, why don't we just not take you home? I will say I find it important to note that these comments were not reported to have come from Ted. All of them were reported to have come from his wife. To my knowledge, he has not been the solicitor of any of these comments. At least not, our child has not indicated that he has. But comments nonetheless. Paragraph H speaks to efforts, overtime, communication breakdown, and those efforts have they've just been gone. There have been genuine attempts to bring conclusions to an effective and respectful manner and have not always done so. Like I said, there was a time in which it was much more positive communication, and then it has been a constant decline. Various things have been blamed on that. Me getting married has been blamed on that. There's consistent blame anytime there's an issue. There's consistent blame that, well, none of this would happen if you wouldn't have moved, which I believe is disparaging all in itself, given that that issue was concluded once we had a confirmed and court-ordered parenting plan prior to my move to Colorado. Unfortunately, a lot of times conversations just have to cease. They have to be tabled because I am not perfect. I have contributed to conversations escalating when I have felt attacked and whatnot, as I'm sure there have been times where it's escalated due to Ted feeling attacked. However, I will no longer entertain conversations where I am cursed at, where I am called names, where insinuations are made, where accusations are made with absolutely no proof or anything behind it. So oftentimes conversations are just ended more or less. Unfortunately, neither of us should or does have the ability to block the other parent. So sometimes there have been times where the conversation has lasted one-sided much longer than it should have, due to that fact, which I think can all be solved with using that third-party parenting app. I can't change the way he feels about me, nor can I change the way his wife feels about me or the situation. But I think we should be able to not say it to each other. Which also plays into the next paragraph, paragraph I, where Ted often fixates on past grievances and will constantly replay old conflicts. It's one thing to say it to me. However, it has also been indicated to the child that it is my fault for moving, for why certain things happen. Specifically, a conversation had happened once. Ted indicated they had gone to do something as a family, which obviously they're going to, and he was just having a conversation. And our daughter made the comment, well, why'd you do that without me? And instead of just saying, well, you weren't here, or maybe we can do that while you are here, something to that effect. The comment, if you lived closer, you could have gone. And if you wouldn't have moved, we could have taken you, were made, which I feel are incredibly inappropriate, given that she does not have a decision in where she lives, where either parent moves to, nor was it her decision or her fault. And that one affected her after that conversation. We had to have a conversation as to why we moved in the first place. Paragraph J, Ted often places undue and unnecessary blame and accountability on me. Again, it goes into the moving. It doesn't seem to matter whether it is a conversation about homework or school or a scheduling conflict. Across the board, it has been an argument that the reason for it is because I moved. The reason for it is because I'm not single anymore. The reason for it is this or this or this. All things that have absolutely nothing to do with the conversation at hand. But worth noting that those things do happen. Paragraph K speaks to the removal of ambiguous wording. There are quite a few places, much like the communication of information regarding travel. There's no real wording for that one. And then there are other places where, like the phone call information, it says that for at least 15 minutes, obviously not taking into account whether or not she is busy or even wants to be on the phone, things like that. I think removal within my parenting plan, I think, at least in my opinion, I've successfully removed any ambiguous wording and replacement with more specific and updated verbiage to eliminate certain scheduling and communication conflicts. One specifically that I have no doubt will be brought up, and I do believe that I do touch on it in my motion and within my parenting plan. When we wrote the original parenting plan, it was written for holiday time for whichever parent had Christmas to have them until the 26th, and then the parent that had New Year's would get the child on the 26th, day after Christmas, and then for the remainder of the break. Well, she was in daycare, she didn't have a break, so to speak. Now she has a 2-week break that encompasses 1 week where Christmas is, and then of course the second week that encompasses New Year's. And that has been a point of, again, what I would describe as malicious compliance. The entire parenting plan, of course, is enveloped in the same phrasing of unless parties agree otherwise. Yet it has been told to me that their household accommodates me on those years where it says that he should get her on the 26th, because then of course he would have her for almost the full 2 weeks, when we had already prior agreed that it was the most fair for one parent to have a week and one parent to have the other week, alternating the week in which we have due to, Christmas and New Year's.
All right, guys, now the case moves into one of the most practical but emotionally charged issues: communication between the child and both parents. Miss Jackson challenges the rigidity of the existing phone and video call schedule, arguing that it creates unnecessary conflict and inconsistency. Examples are given where calls depend heavily on timing, convenience, and circumstances, rather than a stable routine. The argument builds around the idea that the child should not be forced into strict schedules that do not reflect her daily life. Instead, Miss Jackson pushes for more flexibility and autonomy, suggesting that communication should be natural and not dictated by rigid time blocks that often lead to missed or delayed contact.
So I believe that wording of certain scheduling things like that
You
would
need to
eliminate.
point out what specific language you're seeking modification of.
Within the current parenting plan, all of the parenting time that is listed out starts at 7, which I believe is page 5, if I have that printed properly. And within my parenting plan, proposed parenting plan, I outline all of the times in which are indicated in the current parenting plan as well, for each of the holidays as to, odd years or even years, which ones that Ted has. However, I have added specific times for exchange because that has also been a problem. We had
Could you point out to me by page number and location where in your proposal you've set forth your proposal or your modification?
Paragraph 4 under the proposed parenting plan. Some are very small changes. Like A, currently just says, Ted would have parenting time over the Thanksgiving holiday from Wednesday immediately preceding Thanksgiving to the Sunday following. That's where the missing information or more specific wording I feel would be beneficial. That has also been a conversational issue as to deciding when exchanges should be taking place. So really, like with A, all I did was add times that are indicative of when we have already prior agreed to have exchanges for the Thanksgiving holiday. B is where the current parenting plan has incredibly unfair verbiage for her current school schedule. Unfair for both parents in alternating years, saying that that Ted in odd years, Ted would have parenting time over the winter break from the day after the last day to the 26th. Well, on years where he has Christmas, in odd years like this year, he would have her for a total of, I think, 2 days, which obviously is not a fair situation in any manner. And it's also highly inconvenient to be making that drive so close together. And I feel that should be changed, which is what I propose in both B and C, being in odd years, which would be Ted's Christmas holiday, having the child for winter break from the Saturday after class, as opposed to driving so late in the evening in the dark in potentially inclement weather or conditions. So on Saturday at our roughly normal meet time at noon until Saturday the following weekend, which would encompass his Christmas holiday, and give him one of the 2 weeks. Alternately, on years where he has New Year's, he would just have the second week of her winter break. And then it is an even split for that break, and it does not take the holiday away from either parent. Which is actually what we have done. It's just an argument every year as to why we do it and who is being accommodated for. And I think that changing the wording would be beneficial to everyone. Part of the reduction in time that I have requested is not necessarily a reduction in time, but more a sorry, I can't think of the word. Putting more time together in visits as opposed to this issue of a long weekend that has been brought up multiple times between Ted and I, and also removing this one parent picks this time that could change every semester, every year, basically preventing any real ability to talk about it. The way that the parenting plan is currently worded when it comes to the long weekend that Ted gets per semester is that he gets to choose, regardless of what time frame he has to choose it. That has been an issue the last 2 years, though I will note that it only became an issue in the fall of 2023, and I moved in the fall of 2020. So within the motion to dismiss, Ms. Stevens pointed out that that his chosen times for a long weekend are always declined by me, which is categorically false. For 3 years almost, we had no issues whatsoever. The first issue arising in fall of 2023, when I indicated there was one specific weekend that was off limits. And I indicated that in March of 2023. That was due to my husband and I getting married that weekend. So it was one weekend out of the entire semester, there were, I think, 4 other potential options for him to exercise his long weekend. She actually has a fall break. She has a week-long fall break similar to a spring break, as opposed to having onesie-twosie days, like a lot of schools do. He wanted the entire week, and he wanted to pick her up the day after I got married, which obviously did not work out for a plethora of reasons. We were able to kind of squash the conversation during fall of 2023, but it obviously became an issue again fall of last year, where I had to then retain legal counsel in order to resolve the issue again because of the definition of a long weekend. He felt that 9 days, which is what the entire week encompassed, he could consider that to just be a long weekend, which by definition was found to not be the case. We ended up splitting the week, which there were other issues with that as well. But I don't see at this point why there's really any reason for, outside of Thanksgiving or, an unplanned occurrence, should there be reason for it, that there should be anything other than weekend travel. No one should be having to take off work anymore. The way that it was written before, it worked at the time, but really there's really no reason for either side to have to take off work in order to do this. Now, I do understand that Ted has a fairly wavering work schedule. Sometimes he does work on the weekends, but from what I understand, his regular job is a week job, and he does regularly officiate sports. But if we were to accommodate all of that, then there would really be no specific day during certain times of the year that he could travel effectively. So as opposed to having this long weekend, as a definition, and have it change from every single semester and have this be a continued point of contention, I suggest that that we kind of split the time, so that I also have the ability to spend non-school time with her. I've requested that of Ted before. Unfortunately, I was met with a negative response because I don't have a lot of time with her outside of school. And obviously I don't want to take her out of school in order to do certain things. So I asked for a little leniency, was not met positively with that request. So I suggest that in even years, he have spring break. In odd years, he have fall break, and we alternate the two. That way there's no extended long period of time in which he would not have her or not see her. If it was spring break every single year, there would be a long portion of time within the fall every single year in which, or I should say every other year specifically, if he didn't have Thanksgiving, in which he would not have visitation time, which I'm not attempting to,
All right, guys, this is where the discussion intensifies as Miss Jackson introduces the issue of the child's personal cell phone and broader autonomy in communication. She argues that the child should have consistent access to her phone to contact either parent freely, rather than being restricted by scheduling rules. She brings in ADHD as a factor, explaining that memory and routine challenges make flexibility even more important. Privacy also becomes a key point, with Miss Jackson suggesting the child feels more comfortable having independent communication. The disagreement deepens over control, as one side wants structured oversight while the other pushes for independent use. Despite concerns, she notes that parental controls exist and that rules already govern usage at home, reinforcing her argument for balanced freedom rather than strict limitation.
My proposal is for on the even years in which he has Thanksgiving, and there is that time during fall, those even years are also the time that he has spring break, which cuts the spring semester up as well, as opposed to him having fall break and Thanksgiving, and then there being a large gap in spring. Trying to make that the most effective over the entire calendar year as possible. The biggest and understandably the biggest issue that I believe that Ted has taken with my request within the my proposed parenting plan is the reduction of time during summer. This being due to a plethora of things that were lined out within the motion, and not having the ability for the child's thoughts and feelings to have prior been discussed or counted towards anything. 8 weeks is a long time for anyone to be doing anything. We do have it split currently it's written out as a 4-1-4 split in weeks. We do often have to, the last 2 years, actually, we've had to alter that, which has not been without issue, but we have resolved it due to her participation in dance. She has a dance recital with the current studio that she is with, happens to be in the beginning of June, which happens to fall within his currently laid out parenting time. Like I said, we have been able to adjust that, but I think it would also be best to, as I have in the parenting plan, include verbiage to that same effect so that continued conversations don't have to be had about whether something is or isn't fair for one parent or another. He has not lost any time in regards to summer due to the dance recital. He has indicated that he doesn't necessarily find it to be the most important, but to her it is. So I would like for that to be taken into consideration when when and if wording is changed for summer. Like I said earlier, I don't believe that a complete reduction in all parenting time is something that is necessary, because I don't believe that it is 100% of the time that she is miserable or hates being there or anything like that. There are definitely positives that she has brought back from being with her father before. But she has indicated many, many times to me that 4 weeks at a time is a lot and doesn't want to be there for that long. Or after the first section of time, she really doesn't want to go back. Thankfully, that has, as she gets a little older, it has gotten a little better. She's able to handle her emotions more and is able to get through it without as much issue. But I believe that a reduction in time, and at least until which time the two can be on the same page with how they feel. As I indicated earlier, Ted believes it's all positive, and our daughter has not indicated as much. But if things were to change, then the ways that are helpful to her, and she was to feel more understood and more emotionally supported, I feel like that would change her outlook on even being there, especially for longer periods of time. Our current parenting plan in paragraph F indicates Ted having additional parenting time if he will be present in the Denver area and provides at least 2 weeks notice. Unfortunately, this is another means of ambiguous wording causing problems. The way that it is currently worded basically makes it seem as if I have absolutely no control over anything. If he's here and he tells me 2 weeks in advance that he'll be here, I don't have any say. And obviously some things are planned longer than 14 days beforehand. So I do believe that the verbiage needs to be changed. And I believe to be the most fair and inclusive, there should be an addition to, if I happen to be in the Wichita area, I do have family. I'm from Kansas, and I do have family in Kansas. And should I go visit them during his parenting time, maybe be able to take her out to dinner with my mother or, my sister, what have you, would be nice. Currently, there is no allowance for me to do that. And due to the co-parenting issues and communication breakdown, I would not, I likely would not be able to do that. But I do believe it's also important to remove the ambiguous wording that just states that if he is here, then he can have her.
What kind of language are you proposing?
Specifically changing it that if he will be present in the Denver, Colorado metropolitan area and provides me with at least 14 days notice of his intent and has coordinated agreement, meaning that he says, hey, we're planning on being in Colorado, anything going on. And I have the chance to say, actually, she does have this going on. So the rest of the time that you're proposing to see her would be fine, but maybe she has a birthday party, or maybe she has something else going on, as opposed to him just being able to say, well, I'll be there, so I'm going to take her.
Is that language that's in your proposed parenting plan?
Yes.
And where is that located?
Paragraph G and paragraph H. The following paragraph is where I have proposed that it, the same language, but on the other side for me, if I were to be in Wichita. The only change being obviously the end of paragraph G, stating, Ted shall bring the minor child back to Adrian prior to any scheduled extracurricular activities. More regarding, sporting events, things like that. She would often have a game or a practice or something, which may very well happen there. She's not been enrolled in any sporting events or programs that I am aware of, but should that happen over, during the summertime, things like that, obviously that would also need to be taken into account. I would need to get her back to him prior to that. But within both of them, I believe, make sure before I say that. Yes, time pursuant to this paragraph shall not interfere with Adrian or Ted's holiday parenting time, obviously respectively, and time pursuant to this paragraph shall also be subject to the desire of the minor child. Just because I happen to be in town, or just because Ted happens to be in town, doesn't necessarily mean that she's going to want to give up whatever is planned in order to make an adjustment. And I understand that. And I think that should be taken into account. She may not want to forego a birthday party in order to do something different when she had planned to be with her friends. And I do find that to be important as she gets older. That is the paragraph 8 is the last paragraph in the parenting plan, and within, I believe, yes, within the current order, regarding specifics on parenting time. It then goes into where we meet for exchanges. We meet in Colby, Kansas. It's the most convenient place. It's never been an issue outside of inclement weather, in which case we've had discussions, where to meet, altering days, things like that. There's not a whole lot you can do about that. There has been issue with it not being Ted more often than not. And it was within the motion to dismiss, it was brought up that there have been a few times, there have been unfortunately more than a few times. The verbiage of the current parenting plan states a bona fide workplace or medical emergency that prevents a party from making the exchange, in which case a spouse or significant other or family member can do so. However, it does not state an ongoing or recurring workplace obligation, which I believe the argument in the motion to dismiss was. He does have with the sports officiating that he does, depending on the time of year, due to the sport altering what days, he may be on the field. Obviously, it does create a much larger issue for him to be able to be there. Which creates not a bona fide workplace emergency, but a recurring obligation.
All right, guys, in the final segment, the focus shifts to the broader breakdown of respect and communication between the parties. Miss Jackson raises concerns about alleged disparaging remarks made by the other parent and even extended family members, arguing that these behaviors violate the spirit of the parenting agreement. She claims that negative communication has occurred within earshot of the child, contributing to a toxic co-parenting environment. This closing moment reinforces the central theme of the case. Not just legal disagreement, but a deeply fractured relationship that continues to affect how decisions about the child are made and how both sides interact moving forward.